大家坐好，我哋。
I think we can all be seated now, and we'll be starting shortly. The purpose of the meeting today is to listen to the views of deputations and members of the public on the Copyright Amendment Bill 2014. I'd like to welcome all of you first of all to this meeting. Would you all please first put on your earpiece and tune in to the channel of your choice. Channel 0 is the floor channel. Channel 1 is the Cantonese channel. Channel 2 is English, and Channel 3 is the Putonghua channel. I must remind all those present that other than legislative councillors and designated officers attending our meeting, all those attending the hearing today should note that the written and oral submissions will not be protected by the Electoral Powers and Privileges Ordinance. Please also be reminded that those attending meetings in the chamber or the public gallery of this council should draw their attention to the notes for attending electoral meetings, which has already been circulated to you earlier, and table as well today. Those in the public gallery can also obtain a copy of that from our security staff. Our meeting today is divided into 4 sessions since we have many attending. So we are starting the 3rd session from 2 p.m. I shall invite each of the individuals and deputation to speak, and each of you will be allotted 2.5 minutes. When you speak, you only need to point out salient points of your submission, and there is no need for you to repeat the full contents of your submissions. Our usual practice is that the committee has already uploaded the submissions received onto the electoral website. We also welcome all of you to provide supplementary submissions or submissions you have yet to hand in to us after the meeting. Also, when you speak, you may speak in English or Chinese, and please do not use cocktail language for the benefit of our interpreters. So we'll now first of all invite Ms. Clarice Yeung. I am Clarice Yeung from Hong Kong Culture Monitor. At the meeting this morning, Mr. Martin Liu asked why it is that we can put human rights above copyrights. I'd like to point out that between human rights and copyrights, it is undeniable that we should give priority to human rights. Copyrights was only implemented in the 18th century pursuant to a law in order to create the interests or the rights of the copyright owner. We live in a capitalist society, and copyrights can be freely traded in the market. And the original creator very often, I think the relationship with the original creators has been cut off. In our society, very often there is already a bias in favor of the business sector. So in this council, we're now talking about the copyright issue. We're talking about which involve a lot of creative works. If the copyright traders say that they need to use copyrights to protect copyright works, but works created, I think the public should also be given the freedom of creation. And I don't think we should be only talking about parody, caricature, comment on current affairs and pastiche, because someone's creation may not be under those 4 categories. So how should the person, what should the person do in that case? Are we restricting his human rights and his freedom of speech? When the administration is proposing further amendments this time, we are concerned about how we can strike a balance between secondary creation and business interests. In exploring how we can strike that balance, I hope councillors would think about this, that is, whether or not we can protect the interests of those involved in creative works.
As you all may be aware that the copyright ordinance in Hong Kong is very similar to the one in UK. And UK recently has also updated the copyright law in June. They gave exemption to parody, caricature, pastiche, and quotation. The current bill of Hong Kong also follows the same approach of fair dealing. And however, I must point out that even the fair dealings do give exemption to the civil liability under the bill. And however, the threat of civil liability is not therefore eliminated. It is because the current bill of Hong Kong omits a very important part under the same law in UK, which is giving the exemption to contractual liability. Under the UK law, there is a section which states, quote unquote, to the extent that the term of contract purports to prevent or restrict the doing of any act which, by virtue of this section, would not infringe copyright, that term is unenforceable. Without such exemption included in the Hong Kong bill, it means the copyright owner can still initiate civil proceeding for breach of contract. And one may wonder how the contractual obligation be imposed. There are a lot of ways that such contractual obligation can be imposed. For example, when one uses the service on internet, the terms of condition to purchase a product or clicking the agree button to use the website, or when you buy tangible products, there is a terms and conditions in the package, or when you browse a website and there's always a terms of use. Under all these circumstances, a term may have already been inserted to prohibit one to do any acts that is exempted under this bill. But at the same time, the civil liability of a breach of a contractual obligation is still here. The copyright owner can enforce it against anyone who is in breach of the terms and conditions. Therefore, I urge the government that this section to give exemption to contractual liability must also be adopted and copied verbatim in Hong Kong bill. To give full exemption to civil liability to the citizens so that the user's right under the copyright bill can be protected, just like the UK law. As to UGC, the crux is not the international obligations here anymore. The crux here is that the government must address the enormous public voices to demand a wider exemption. The legislation group are open to discuss the ambit of the UGC exemption, for example, imposing more conditions. We urge the government to answer to this strong demand of an UGC exemption. Thank you.
Okay, thank you. 下一位係溫家榮女士。
主席好，大家好，我唔
Chairman, I'm not a legal expert. I'm just an ordinary citizen. But I'm also someone who would like to do creative works. I have a YouTube channel on the YouTube, and I would like to produce my own rendition of the songs that I like. I noticed in the 2011 bill that the amendment to the copyright ordinance would result in people engaged in secondary creation fear that the creative work would be affected. In the 2014 amendment bill, indeed, the administration has expanded the exemptions for the public. There are many provisions for parody, satire, comment on current affairs, and pastiche. But there is one area which has not been given exemption, that is personal derivative works. Under the current bill, and again, I'm no expert in the law, but I have not found a clear provision to protect those people who just want to sing, for example, the song Under the Lion Rock and upload it onto the internet. Because if I give my own version of the song, I'm not protected by the law. I think everyone is born to loving to sing. So I don't know why this inborn ability to sing should be constrained by the law, so that we are deprived of simple entertainments like singing. So today I'm not here just to represent people who do creative works on the internet. I also want some clear provisions in order to protect myself. In my submission, I've said that the UGC option is something that the government could consider, because its exemptions are more open and it doesn't just exempt a few areas. I therefore, the fact that I hope that the government will listen to the voices of people who love to sing, and that they will be given, sufficient protection. Next, Mr. Chen Kai-him, Chairman. I represent I gasped in awe every time I see CY Leung Alliance to object the bill. The most controversial part of the bill is about the UGC. The government tells the public that the amendment will protect the interests of the copyright owners and also people involved in derivative works. Our alliance believes that after the amendment is accepted, you can protect the rights of copyright owners, but not in the case of those involved in derivative works. The bill provides for certain exemptions, but I'd like to know whether or not creative work could be regulated like that. Why is it that you can have exemption in one area and not the others? What are your criteria? If there is another form of derivative creation, appearing tomorrow, how should they be exempted? So some people may think that the secondary creation is too complicated. If I don't understand, what should I do? The simplest thing is that you go home, you listen to a song, you want to change up the lyrics, you sing your own version, put it onto the YouTube and share with other people, and is that not allowed? If you did that, you would already have been prosecuted. Our alliance understands that the copyright owners would like to protect the results of the creation, and that is not questionable. The efforts of those who create such work should be protected. The government should protect the interests of both sides rather than neglecting the right of the general members of the public to engage in secondary creation. Some people say that the bill is the article, the equivalent of Article 23 on the Internet. Those who support the amendment and the copyright owners, the government say that it doesn't want to stifle the freedom of expression. But the people are worried because they're worried that this article will allow people who have the power to abuse the law. The government say we can trust the administration. It won't do that. I hope that the officials understand that you are representing the government. What kind of government that you are representing? Is the government? 10 years ago, certain persons said we'll never test and connect. Yes, sure, now never deploy the riot police or use tear gas. So after what has happened recently, how can we trust the government? Our alliance demand that the government should do away with the unnecessary regulations on derivative creation. And I will now repeat in English. The time is up. I'm sorry. Mr. CHU Kin-sun. Thank you, Chairman. I'm just an ordinary member of the public, and I strongly object to the 2014 Copyright Amendment Bill. The reason is that we want to protect the room for secondary creation, and we want to strike a balance between the interests of copyright owners and secondary creation. I think we should allow more room for the public to engage in secondary creation. I don't think we should stifle the freedom of creation. I hope all legislative members will hear the voice of the people. Thank you. Next, Ms. Chong Si-wai. Ms. Chong Si-wai? Or Ms. Chen Sin-tong. Thank you, Chairman. Actually, every time I see I see the spokesman of our alliance has already said most of the things I wanted to say, so I don't think I have anything further to add. Ms. Hao-Hiu-tong. Thank you, Chairman. Chairman, again, I'm just someone who would like to, do secondary creation and derivative works. I've been advocating and promoting derivative works. I've also built a platform for people to exchange ideas about derivative works. 4 years ago, I helped Hong Kong comics. Nobody had previously engaged in such derivative works that attracted a number of fans who were able to organize activity to sell their derivative works. After I've organized that event, not only did the original copyright owners knew about it, we were able to also have exchange of ideas with the original author, and we have not really, hurt the sale of the original comics. Instead, its sales has gone up. It has simply created a new group of readers. So the original author and those doing secondary creation are actually in a mutually beneficial relationship. I think the mood in Hong Kong at the moment is not very good at the moment. There are not many people buying comics in Hong Kong. As a result, some of these the people who are doing such creative works will leave Hong Kong. Many of my friends who will not be able to sell too many of their derivative works, if they can't even sell it for $1,000, they can go to Taiwan or the mainland and can sell the works for that much. So they will move to other markets. Furthermore, the 2014 bill will further, I think, stifle those people who would like to do creative works in Hong Kong, and that is really sad. So even if I encourage people to do creative works, I wouldn't be able to see the results of their creation. Ms. Kam Wai Chung, Chairman, I object to the copyright amendment bill. Our chief executive is not popularly elected. There's a lot of pent-up grievances in Hong Kong, which is evident to all. So I think the amendment bill aims at, silencing the public. There are many people doing secondary creation. They're actually speaking out on behalf of the people. The copyright amendment bill aims at silencing the public. If we should lose our right to speak out, I don't know what we should do. That's all I wish to say. Next, Mr. Lee Pui-yut. Good afternoon. My name is Lee Pui-yut. When I saw an advertisement last year, I think I can repeat what I've said last year, because this year the number of councillors present is smaller than those last year. The 4 exemptions and current affairs exemption are only minor improvements. If we use this photo, the cosplay photo, again, I must say that after 2 years. Even the Federal Trade Union, with what they have done, is likely to be prosecuted. So you have this cosplay. We're talking about the clothes that they made is illegal, and the government is. So this cosplay dress, if one wears it in public, or if the reporter has taken these 2 photos, he is actually communicating that photo. And according to Section 108, the extensive communication of the product, he will have to make compensation to the author. He will have to be asked to pay an additional compensation. Even if the government is now proposing 4 exemptions, and the exemption for commenting on current affairs, well, if this looks funny to all the members of the FTU, they can still be. They have to prove that this is indeed caricature before they will enjoy the exemption. So I've put that photo just now to make the point that that it cannot protect people who are engaged in second creation. Our association, I think TONG Hung-man is a culture that should be respected. And what they create does not conflict with that, with the original work. As in last year, I strongly urge the government to consider the UGC option so that we can protect such creative efforts.
Next one, Doomsday. This is my pen name, and I am a columnist in Hong Kong. I believe I belong to this industry. Now, I'd like to talk to you about a world where there are no boundaries. Confucius said that if the world is an ideal world, everyone should be equal, everyone should be able to work at his best for the good of that world. It's like utopia. It looks like it's very distant from us, but actually it is not that distant. In some ways, we can achieve utopia in our real world. And I'd like to talk about a Japanese website which uploads movies for the use of netizens. There is a very famous song of that website. It's called Nico Nico. And the song is taken, or a product of clips taken from famous movie songs. At the beginning, it was just music. And people just did a mix of the different sounds. And then later on, people added lyrics. People added the visual. And then somebody sang it. And then in the end, it was a chorus. And then in the end, it was quite a movie clip. What I like to say is that actually people can contribute their talent to whatever is uploaded on the internet and enrich it. So this is what an ideal world is. In other words, people contribute their part. And to achieve that kind of utopia, you need to impose no bounds to creation. If you limit people to doing just certain things in a certain area, then what I said as an example will not come to pass. Human beings have a few thousand years of history, and we have finally got the internet, which is a gateway to a possible utopia. And why do we want to stop people from achieving it just because of the consideration of economic benefit? In fact, the secondary creation can benefit the original because people would be led to appreciate the original as well, because people won't buy a disc of the secondary creation. They would go for the original. So I don't think we should put any boundaries on this. Thank you. Next one, Mr. Young Tong Yun. Chairman, good afternoon. I come here in my personal capacity. I have seen this paper, and I think there is a small problem here. Let me say that I am an apps developer. I can see that recently there are government policies which have caused the dissatisfaction of the public. And I wanted to write some apps to reflect that. But during the stage of creation, and I read this paper, and I have found that there will be many things that I cannot do. And if I do those things, I may be caught breaking the law. In other words, if this bill will become law. For example, satire. I, of course, will satirize what is happening in society, in other words, current affairs. And I want to tell people that this is my intent. However, how can I prove my intent? And if I take up a certain part of the original work, would people agree that I'm only using a certain percentage? I would be satirizing current affairs, but other people would say that I have ventured into different areas and different levels, and then in certain parts of my creation, I would be breaking the law. And if that is a possibility, I would choose not to do that for the moment, and then I would have to look up so many things to see whether I would break the law before I would do creation. And then I read on, and I have found some exemptions. However, those exemptions would be very difficult to achieve in an individual's capacity. You need the permission of the person holding the copyright. Now, if I find things on the internet, how can I go back and trace the copyright owners of all those things? Say, if I like to use a section of a musical production, and I would be able to, I want to use that, and then I want to use a capture image from another clip. And how can I go to all the copyright owners to get permission? And of course, they provide A, B, C, D, so on and so forth for authorization, permission, etc. And whether the copyright has expired. I would have to look up all that information before I take the first step. And then I may be too daunted. I would say I'd rather not do the creation at all. Next one, Mr. Chan Yet Hang. First of all, let me state my stance. I strongly object to the bill. Very many of us are here to express our views because we don't trust the government. Recently, the enforcement standard of the government cannot be trusted, and you move the goalpost, and we have to go to the court in order to get justice. And if we do creation, we may need 1 or 2 years to wrangle with the government. I mean, we don't have the time and money to do that. And in the end, we would just say, sorry, I would say I'm wrong, and also we have to pay compensation. And also, very often when we do secondary creation, a lot of the original material would come from the government, and the government says, I have the copyright, and you are not under the 4 major exemptions. And then you can use this law to take us to court, and we are no match if you do that. And I can give you an example. Mr. Xi Jinping has held up an umbrella in a photo, and it has been used for secondary creation to a very large extent. Now, that copyright belongs to the Chinese government, and the Chinese government can make use of this law to take us to court. I mean, we are no match with the Chinese government in terms of money and manpower. So we'd like you to tell us exactly how the exemptions can really function under this law so that there will be freedom of creation, and so that at the same time you can protect the rights of copyright owners. And I can also quote an example. I deal with language, and if Chinese history has a copyright owner, then we would not have any creation from the famous novelist Jin Yong, because we can't even make use of history of the Qing dynasty in order to do secondary creation. Thank you very much for your patience. Mr. Law Kin Chung? Yes, I object to the bill for a simple reason. The administration is ruling by the rule not of law but by law. I can say that Mr. C.Y. Leung was not taken to court because of UBW, but Henry Tang was. And why UBWs in small houses were not taken down? Mr. Chen Kam Lam, you also had UBW at your house, but you were not prosecuted. That's all I like to say. Next one, Mr. Wu Qin Chiu, Mr. Chai Ki-hu. There are so many people who have registered to speak. Why? This is because we are fighting for genuine universal suffrage, and at the same time we are fighting for genuine exemptions. We don't want to pocket the false exemptions. What do we mean by false exemption? The administration is saying that they would exempt parody, satire, caricature, and pastiche. And they say you can do comment on current events. But how do you draw the line? How can you say whether a particular production is a satire? You can ask different experts to argue whether we have made use of a poem and done some satire on it. Who should we listen to, even if they are all prominent literary figures? We'd like to ask for real exemption. You say you are defending a business model. What kind of business model is that? You quoted an example. You say we can have new lyrics for old music, but still that would not constitute any exemption. Why? Because Mr. C.Y. Leung has said that those who earn less than $14,000 a month should not have a vote. In fact, one copyright owner told me that, Mr. Wu, if you put new lyrics onto my music, you will have to give me $100,000. And if you do that, I would lose $100,000. In other words, if you don't have $100,000, you cannot fill some music with new lyrics. That is the business model of IFPI. Is that justice? Do we want to defend that kind of business model? Because originally the music is not for profit, but then if you put new lyrics in it, you will have to pay them a hefty sum. I believe that constitutes some constraint or limitation on creation. We want real freedom of creation. I think there is a public policy cause for it. We are talking about user-generated content. We like to have real exemption for it, but then you talk about a three-step test, quoting the WTO. I think that is distortion of the WTO principle. Many experts have said that UGC will not be found undesirable under the three-step test. We are talking about technology-neutral creation. We also like to monitor and regulate the licensed companies. Sorry, your time is up. Next one, Ms. Wong Chun Fong. Thank you. I'm just an ordinary member of the public. I object to the 2014 Copyright Amendment Bill. First, I think this bill stifles freedom of creation because you define publication in a special way, so there cannot be free creation amongst the public, and we are very worried that we will be easily caught by the law. We are worried about freedom of expression, and also freedom of creation will also be stifled. As other speakers have said, just like the photo featuring Mr. Xi Jinping holding an umbrella, he was put on top of Lion Rock and in different places. Well, it's a kind of commentary or satire on current events. However, even if you do that, you will not be protected by this law. Some people may say it's not a satire on current events, and we can hardly argue with the government. Last but not least, I think the bill also derogates from freedom of the press. Right now, the Hong Kong laws give too much privilege to the government and the Hong Kong police, and I'm afraid that if the bill is carried, the administration can make use of the law to arrest people and stifle their freedom of expression, because people may be creating photos and literature that is not liked by the government, and the government can take them to court for infringing on copyright. Just like the umbrella movement or revolution, if some photos or literature is used and they are uploaded onto the web, and people would say it is an infringement of copyright, and people would remove those productions, and then if they are successful with their objection, then of course they can upload the productions again. However, there will be a long time gap, and the productions will be kept from the public for a long time, and in the end, even if they are allowed, they would be outdated already. Thank you. Next, Ms. Shuang Shi. With the widespread use of social network, you can share photos and clips, and people will be attracted, and you can pull a big group of people who are your followers. In fact, many writers don't have to go to publishers. They can start a Facebook page, and then people would be attracted to it, and then the publishers would actually get them to write for them and create photos for them. Very often, Now creative people would just upload their productions onto the internet, and they would be featuring things they come across in their daily lives. And very often they also make use of, say, for example, Korean soap opera on TV, and they would use, for example, the very famous My Love from the Stars. And also some people liked the giants in a certain comic movie from Japan. And sometimes they would liken these people to famous people in Hong Kong. And then they would do secondary creation and upload these clips onto the internet. Some people will also sing some songs in different ways and share them on the internet. In Japan, some of these people actually were so very much attracted, and then they eventually became singers. And such creative format has dominated the internet in Hong Kong. They're all derivative works. They are all secondary creations. In fact, academically, secondary creation is called an expert name. It is also defined academically. It is not the same as infringement or copying other people's works. And secondary creation is not to steal other people's works and make them your own. Quite on the contrary, you would make use of the basic elements, and then you would further develop them, and then you would give them a different tone. And you can see that the secondary creation is something quite different. Sorry, your time is up. Miss Winnie Hung? Yes. I'm an illustrator. I'm an artist. I strongly object to the bill. I have heard other people talk about sharing things on the internet and also secondary creation. And I can't understand one point. Why is it that you are talking about secondary creation and yet you don't tell us the criteria you are going to use to deal with secondary creation? Very often, we do secondary creation, and we are talking about the 21st century. We may be using ideas that have already been expressed to express ourselves. But where do you draw the line? You are not telling us. If, say, I am involved in creative works, and if I think that somebody is copying my works, I think you should ask me instead of just applying the law on the person doing secondary creation. I'd just like to tackle this point. Now, of course, there will be a lot of constraint on creation. I would apply my independent thinking, and I would like to speak through my works. And if you use this bill, there will be a serious suppression on creation. The Hong Kong administration always says you would like to support local creation. Well, in fact, this is going to be such a high threshold, and then these are vicious laws which are very unreasonable. You're not supporting us, you're suppressing us. How many things are you helping us to do? I don't think so. I hope you will just leave us alone, okay? Don't say you support us and then suppress us. Just leave us alone. Let us just express our creative talent in an organic way ourselves. I hope you would also review the criteria that you are going to apply. Thank you.
Thanks, Mr. Lam Chi-fai. Thank you, Chairman. First of all, I would like to protest 2.5 minutes. It's too short. A lot of people have talked about secondary creations. And you are going to add 3A, that's 88A to 88J. You will make some changes. Now, first of all, I would like to say no to this. 88D, you use the word positive obligation. That is when you legislate, the OSP would have to take the initiative to abide by this, to discharge this duty, and he has to comply with 88B2, then he does not have to bear the responsibility. This is totally against the usual way of drafting law. That is how normal people should order a certain liability. It should not be this kind of obligation. And then 88B2B, it says that you cannot get any benefit for doing this. Well, how can an OSP not charge its subscribers? So for the whole of 88B, the way it is drafted is a trap. And then 88C, the infringement notice, the and then under 88C2, you have to do other things. But if we compare the relevant law enacted in China in 2005, even on the mainland, when it comes to managing the internet, if you want to say that your copyright is infringed, you have to produce evidence in writing before asking the OSP to take action and take down the relevant content. So we really are more backward than the mainland law. Due to a time constraint, I cannot give you all the details. But for 88A to 88J, these are provisions that are giving a lot of limitations to OSPs, and it is almost like a white terror, and the OSPs would have to censor their contents proactively. This is extremely unacceptable. Thank you. A lot of representatives and deputations have expressed their views. And today, we have 4 government representatives with us. We have from the Commerce and Economic Development Bureau, the Deputy Secretary, Mr. David Wong, Ms. Fabia Tam, Assistant Secretary for Commerce and Economic Development, and Assistant Director of Intellectual Property, Ms. Michelle Chong, and Ms. Jasmine Kun, Senior Solicitor. The Deputy Secretary has had a lot of views. Just now, do you have any response? Thank you, Chairman. I would like to thank the deputations for taking the Saturday off to come to tell us their views. We have listened carefully to their views, and we will also look at their submissions very detailedly. As for a copyright regime, the legislative intent is to encourage creativity, and the spirit is that after certain creative work, when there's a product, no matter it's a film, it's a picture or what, then the legal system should provide legal protection for it. So it's like property right. By doing so, we can encourage creative people to create, so then they can get a return for what they create. This is a fundamental points about copyright regime. Now we use the concept of property right, and the creation result will be protected. But is this property right an absolute right? Not necessarily, because we also accept that this is an intangible right and is not absolute. Under certain circumstances, even though without the consent of the original creator, if you use his work, it may still be lawful. So that's why under the existing copyright ordinance, we have already over 60 provisions that are providing exceptions. Even though without the consent of the original creator, you can still use the copyright work. And for our bill, we uphold the same spirit, but we have to catch up with the developments of the Internet. Now, because many infringing activities may not be relying on a copy, you can just disseminate certain things on the Internet, and you can use streaming. So in the legal framework, we have to catch up with the digital developments. The copyright owners should have certain rights to communicate their works. And also we have to accept that other than providing protection, we have to look at the actual situation. That is, whether the exception is enough to cater for the present situation. So that's why we now are proposing 6 types of exceptions. Now, with this and the existing 60-odd provisions, the digital environments can be addressed and adequate exceptions can be provided. There are 3 exceptions that have been added after the last consultation. Now, we have looked at other countries' practices, for example, EU, Canada, UK, etc. Now, the first is parody, satire, caricature, and pastiche. Now, many things happening on the Internet are about parody and satire. So these are the scenarios that we want to address. And the second exception is commenting on current events. These can be used as a reason for exception. So other than reporting current events, commenting on current events can also enjoy exception. This can take care of the present situation in society. And third, quotation. That is, you make use of something to express your views. For example, capturing certain images or altering pictures, etc. Now, there are things that we do not think that they should enjoy exception. For example, earnest performance of copyright works. Some people said just now they want to sing songs and then upload them onto the Internet. Now we do not have an exemption. When you do this, it's in an infringement of rights. Yes, but we understand that society is developing. There are YouTubes, there are a lot of websites. So agreements have been made. For example, YouTube would pay to certain copyright owners so that songs can be played on YouTube. So this is already happening. It's not only in Hong Kong, in the US and other places. They have already adopted this kind of business model has been adopted. So the website allows its subscribers to do certain things, and the host of the website will pay. And about safe harbor provision, it serves to protect 3 things. First of all, the platform. Now, with the safe harbor provision, there are certain limitations. That is, if the OSP do some reasonable things, then that will be okay. And second, about copyright owners, if there is infringement of copyright, the copyright owners can protect their interests, and it can also protect the subscribers. If the subscribers do not agree to the allegation of copyright infringement, then they can serve a counter notice. So we are taking care of the interests of 3 parties. As for safe harbor provisions, they have been implemented in other countries for quite some time, for example, the US. And we see that a reasonable balance has been struck. For example, the US Internet is developing very rapidly. As for the details and technicalities, we will discuss them with the Bills Committee so as to ensure that the bill can take care of the needs of different parties. Thank you. Members, any questions? Mr. Charles Mock, Chairman. Just now, the last speaker, I remember he mentioned that whether OSPs would have to take the initiative to censor the contents in order to enjoy the safe harbor protection. If that is the case, the netizens will be in great fear. So can Mr. Wong explain more about this? Will the safe harbor provisions be used in this way? Maybe I can try to explain. With regard to the operation of safe harbor, just now Mr. Chen asked some questions. That is, whether an OSP would have to take the initiative to censor, to police, and to take down. That is, the responsibility would be placed on the OSP. No, that is not the case. If you look at 88B, or the whole safe harbor mechanism, actually it is a statutory safe harbor, and it is a protection. If you try to understand it as a protection, then you will not view it as a responsibility. But if it is a protection, or if you want to exercise the safe harbor right, you have to take certain steps. And the law says that if you have taken such steps, then you will be qualified. So the perspective is different. If you use the English term obligation, it is not an obligation, it is a benefit. This is point number one. And for 88C, the OSP would have to take the initiative to take down certain contents and to police their service platforms. That is not the case. The mechanism is like this. If the copyright owner knows that on a certain platform there is some infringing copy, then he should provide information and he should list out such things on the infringement notice. He should notify the OSP, and after the OSP receives these, and if all information is provided, he does not have to verify the information. What he needs to do is to notify his subscriber. It does not have to disclose the information or data of the subscriber to the copyright owner. He can just tell him that now you are suspected that you have infringed other people's copyrights. So you just provide a notice to that person, and after a certain period you can take down the relevant content. Now if the subscriber thinks that he's not infringing anybody's copyright, he can send out a counter notice, and the OSP can then reinstate the material it has taken down. Now, if the copyright owner applies to the court to start certain procedures, or even if he has obtained an order from the court, then the content or the material would have to be taken down again. Then the person being complained against and the complainant can solve the problem in court. This is the mechanism of the safe harbor. Just now, the representative said that OSPs are asked not to take any benefit. That is not the case. What it means is that through this kind of infringing activities, the OSPs should not be able to obtain any benefit, because the OSP should be an innocent third party. In case of possible copyright infringements, the OSP should be a third party, so he should not be making any profit from this kind of activity. That's why we have this provision. The OSP cannot or is not allowed to make any profit from any possible infringing activity. This is in line with international rules. For USDMCA, they have already stated this very clearly, and there are a lot of precedent cases. So there are clear definitions. These are the clarifications that I want to make because there may be misunderstanding among members of the public. Chairman, can I follow up with a short question? Because today we do not have officials from the Department of Justice, maybe they cannot answer this question right away. I think in the communication ordinance, as to whether the communication operators would have to do policing, etc., I think they have some provisions about this. And also there are some requirements in their licensing conditions. Now, OSPs may not be communication operators, and some of them are just discussion forums. So I would like to know that whether there are certain limitations in the law in this regard. Yes, we'll go back and take a look at this, and then we will provide information to Mr. Mok after the meeting. Yes, if there are no other questions, then let's wrap up the discussion of this session. Chai Ki-Wu, what do you want to add? I'm sorry, we have to follow all the procedures, and we have completed all the procedures, so we should adjourn this session now. You may leave, and the next session will start at 4.